discharge.
This appeal is against a judgment and order dated 18th February 2020 passed by the Chennai Regional Bench of the Armed Forces Tribunal, allowing the application being OA number 53 of 2018 filed by the respondent about 20 years after he was discharged from the Indian Army, and holding that the respondent was entitled to disability pension. The arrears were restricted to a period of 3 years prior to the date of application before the tribunal. The respondent was enrolled in the army on 26 March 1987, but an order dated 5th April 1997, the respondent was discharged from service on administrative grounds as an undesirable soldier under Rule 13 within bracket 3 of the Army Rules 1954. The respondent that rendered service for 9 years, 7 months and 1 day, excluding 161 days of non-qualifying service. Annexed to the appeal is a copy of the order of the certificate of the commandant dated 12th October 1996 regarding the proposal to discharge the respondent. As per the certificate of the commandant, service of the respondent was no longer required. The cause of discharge was shown in paragraph 20 as undesirable soldier under Rule 13 within bracket 3 of Army Rules 1954. At the time of discharge, the respondent was in low medical category. A meeting of the Release Medical Board held on 30th January 1997 found right partial seizure with secondary generalization 3, 4, 5 neither attributable to nor aggravated within bracket NANA by military service. The disability was assessed at the rate of 20% for 2-4 years. The respondent did not challenge his discharge under Rule 13 within bracket 3 of the Army Rules 1954 as an undesirable soldier. The respondent, however, made an application claiming disability pension by order number G3/85/318/11/297 dated 19th May 1998. The offense of the Chief CDA Allahabad rejected the claim of the respondent for disability pension. Relevant part of the said order read as under para. Accordingly, for clauses within bracket small a and within bracket small 2 of para 1 above, no disability pension is admissible. Under the existing rules, the above decision may be communicated to the individual under registered post along with the MS finding, and a clause may also be added therein that he may appeal against the decision not later than 6 months from the date of issue of this letter on such grounds as it may deem fit to put forth, if desired by him, a sum of rupees 10,000 on account of invalid gratuity and a sum of rupees 15,000 on account of DCRG has been admitted in case the individual dues before receiving DCRG amount it should not be paid to his heirs, and the matter referred to G4 section of this office para. On 6th October 1998, the respondent filed an appeal against the rejection of disability pension. The appellate authority rejected the appeal by a communication dated 11th January 2000. The respondent was informed that his appeal against rejection of disability pension had been rejected by the first appellate authority on 25th August 2017, that is almost 20 years after his discharge and over 17.5 years after the dismissal of his appeal against the rejection of disability pension. The respondent sent a legal notice claiming disability pension on the ground of parity with 1 DC and 1 RC. The case of the respondent appears to be distinguishable since the respondent was not discharged on medical grounds. Unlike RC or DC, it appears that in course of his career, the respondent had earned red ink entries in his service records on 7 occasions as per the particulars given herein below. The appellant's content that the respondent was a habitual offender who kept breaching military discipline notwithstanding repeated counseling and advice given by his superiors. He proved to be an insufficient soldier. Be that as it may, the fact remains that for 20 years the respondent did not question his discharge by a communication dated 27th October 2017. The appellant number 3 replied to the said notice stating, you have been discharged under RB Rule 13 with bracket 3 being undesirable soldier and not invalidated out from service as mentioned in your above legal notice. Hence, the disability pension is not admissible as per existing rules in force. Being aggrieved, the respondent filed OA number 53 of 2018 before the tribunal claiming disability pension and the benefits under Regulation 183 of the Army Pension Regulation 1961. The application has been allowed by the judgment and order impugned. Well, at the cost of a repetition, it is reiterated that the respondent was discharged under Rule 13 within bracket 3 of the Army Rules 1954 on administrative grounds as an undesirable soldier and not on the ground of medical disability. Any opinion of the released medical board held on 30th January 1997 with regard to the ailment of the respondent does not entitle to respondent to disability pension as the ailment did not lead to his discharge. Stop.